Hello and welcome to FFRF's Ask an Atheist. I'm Laurie Gaylor, co-president and co-founder of the Freedom from Religion Foundation.
And I'm Liz Cavell, associate counsel at Freedom from Religion Foundation. And today we're going to discuss the latest developments in the extremist crusade to end all abortion in the U.S., especially the latest attacks on medication abortion in the courts. As always, you can join in our conversation by making comments below, or you can email askanatheist@ffrf.org. We have two guests joining us via Skype to give their expert perspectives. First, welcome Professor Caroline Corbin. She is a professor of law at the University of Miami. She teaches all manner of con law courses, including on the religion clauses. And before academia, her long career included work in the reproductive justice movement as a lawyer. Welcome, Professor Corbin. Thank you so much for taking the time to join us.
Always happy to join you.
And also joining us to talk about all of these developments is Barbara Alvarez, formerly the Ann Nicole Gaylor Reproductive Rights Intern, now a contributing writer for FFRF. Barbara is an instructor in library and information science and is a Ph.D. candidate in information science. And her second book for the American Library Association has just been published, and it's called The Library's Guide to Sexual and Reproductive Health. And it's a beautiful book, as you can see, hot off the press. Welcome back to FFRS Ask an Atheist, Barbara.
Thanks so much for having me. It's great to be here.
So before we talk about all of these updates and developments, I did want to just ask you about this new book and why it's so needed.
Well, I think that this book is especially needed right now because reproductive justice is not just a public health issue, but it's also an information access concern. And we're seeing that so much across the country with the recent developments in abortion legislation. It's not just against the procedure to get an abortion, but also seeking information about abortion access. We're seeing legislation introduced that would ban schools and public libraries from accessing websites about abortion. We're seeing legislation introduced that would restrict state employees' abilities to speak about abortion. Even right after the Dobbs decision in June, we had legislation that went into effect in states like Idaho, where their university staff were prohibited from saying that that condoms prevent pregnancy. They could only say that condoms prevent sexually transmitted infections. Information access and reproductive justice have been intertwined for much longer, though, than the Dobbs decision. We have anti-abortion centers, also known as crisis pregnancy centers, that receive tax dollars and shared blatant disinformation about reproductive health, especially abortion. We have Catholic hospitals that also receive tax dollars that do not let people know that they follow religious directives on their website and therefore do not provide certain sexual and reproductive health information. We've had doctors, physicians who are required by law in abortion counseling sessions to say that abortion may cause infertility or psychological distress when none of that is true. So my aim for this book is really to bring together sexual and reproductive health and information access. And I feel that that has been needed for a very long time, but it is especially needed right now. And I didn't see that there was a platform for this for information professionals, specifically librarians, and I decided to go ahead and create a guide for it.
Well, and I know that you are also going to be speaking at the national conference of the ALA, I think in June. And
yes.
So people can look this book up. Thank you.
Yeah, thank you so much for sharing it.
Also love that cover art. That is currently my favorite uterus art. It's beautiful.
It really is. They had posters for it available at a conference in January. I think they did a fantastic job with it.
Yeah. So let's just jump in and talk a little bit about the latest that's been going on in the courts, further attacks on abortion and abortion access. So most notably, a few weeks ago, we all saw headlines about the Supreme Court weighing in on this case, a lawsuit out of Texas, which is basically asking the federal courts to effectively ban the drug mifepristone, which is used in more than half of U.S. abortions. The case is called Danko Laboratories versus Alliance for Hippocratic Medicine. So I want to start with Professor Corbin. Can you just give us the short version of what this case is about and how the Supreme Court got involved? What's the update?
Okay, so just a little bit of background, just so people understand that there are two very different ways of ending a pregnancy. One is the familiar traditional by surgery, and the other is via medicine. And the medical abortion is a two-step process. And the first, you take one drug, the mifepristone, and then a day later, you take another drug, and they do slightly different things. And as you mentioned, over half of abortion now are by the medicine rather than the surgery. And so what's at issue is the first drug in that sort of two-drug protocol, the mifepristone. And so a group of pro-life doctors and organizations challenged the availability of this drug, and they did it on two grounds. First, and primarily, they argued that the FDA approval of this drug was unwarranted, that they did not follow proper procedure when they approved what they described as this very dangerous drug. It's not, it's incredibly safe. So that was the first. And then they went on to add that also there's a law from the 19th century, the Comstock Act, that forbid the mailing of anything that is related to abortion. And they said it also violated the Comstock Act. So two things. First, the FDA should never have approved it in the first place. And second, it's illegal to mail this drug because of the Comstock Act. And they filed in a very friendly district court, and they knew it was going to be a very friendly district court because they selected the only judge. They selected a place where there was only one judge, and that judge was notorious for his anti-abortion views. So that's the lawsuit. Not surprisingly, he ruled in their favor. And it got to the Supreme Court because there was an application for an emergency stay to sort of say, listen, this is the district court. There are 3 layers of federal courts. So the district court is not the final say. It's going to be appealed to the Fifth Circuit and then ultimately to the Supreme Court. That's a very long process. So while we wait for the judicial system to consider the arguments as it goes up, you can ask a court to say, hey, can we just hold that, put everything on hold for a moment? And so what happened is the Fifth Circuit applied for a temporary stay with the Fifth Circuit, and then it went up to the Supreme Court. And Supreme Court did in fact say, hey, we're not going to let this ruling go into effect just yet. So right now, today, the drug is as available as it was before the district court decision. But that can change because it's just putting the decision on hold temporarily. Now what we have is the Fifth Circuit Court of Appeals, the next court, right? So district court, there's one judge. Then the Court of Appeals, in this case, it's the Fifth Circuit. There are 3 judges. They're about to hear oral argument in this decision. They, too, are hostile to abortion. So their ruling's not going to be ideal. And then it'll go up to the Supreme Court again.
To say the least, because we were just talking before the show. Liz, you were telling us what the draw is, the 3 judges.
That's right. So the circuit courts draw a 3-judge panel out of all the judges on the circuit to hear any given appeal from a district court. And the panel that is going to hear oral arguments on the mifepristone case on May 17th was drawn either this morning or yesterday. And it is a very, the whole circuit is ultra conservative. It is a extremely conservative panel with all sort of noted and public anti-abortion views and prior rulings. So it does not bode well. 2 Trump appointees and a George W. Bush appointee, all with anti-abortion rulings in their past.
So, Professor Corbin, what could happen on May 17th after that hearing? What could we expect the Fifth Circuit to do?
So they are going to reconsider the challenges, right? Did the FDA did the FDA fail to follow protocol when it approved this drug? And by the way, it was approved 20 years ago. So in that time, it has been used by millions of women around just in the States, it's been widely used, never mind around the world, with no ill effect. So they could agree with the district court that the FDA should not have approved it in the first place. They don't necessarily have to go that far. And in fact, the first Fifth Circuit panel to hear it, they didn't say that the drug should be off the market entirely, but they did try and curtail some of the increased availability of the drug. So since it's been originally approved, the window for its use has been expanded from 7 weeks to 10 weeks. And then the FDA sort of removed some additional limits on the drugs to make it available via telemedicine and mail. And they said that these expansions were illegitimate. So the original Fifth Circuit decision was bad, but not as horrible as a district court. So there's sort of a range of bad decisions we could expect. It could agree with the district court wholeheartedly, or it could still make things harder for women by saying, okay, the drug can be on the market, but you can only use it for the first 7 weeks, and you have to go visit a doctor numerous times in order to be able to take it.
Up to 3 times.
Up to 3 times, right?
Which is
because
ridiculous.
You have to visit a doctor, get this faux counseling, and then pick it up.
And isn't it true that, most women don't know they're pregnant at 6 weeks, so it's really a 6 or 7 week ban. It's a ban.
It can make, yes. If you have to take it before 7 weeks, the window is slim indeed.
So all sort of consensus is that this case will probably find a friendly hearing before the Fifth Circuit and is ultimately headed back to the Supreme Court. Do you have any predictions or ideas about what could happen and how soon? Obviously the Supreme Court could go along with this whole thing, but I think the consensus among lawyers in the legal community is that this case is just, in terms of the legal basis for claims, is just unprecedented, right?
It is absolutely unprecedented. Once the district, never before has the court said to the FDA, you do not know how to do your job. It is just, no court has ever said the FDA has not followed procedure in approving a drug. So yes, it is unprecedented, and I don't know what the Supreme Court is going to do with that. Its hostility to abortion is so palpable, and it has distorted so much other law in order to get an outcome that is inimical to abortion. I don't know if it will go as far as now allowing courts to second guess an agency in its area of expertise.
So that's what gives me a little hope, is that this is a very pro-business court. So now we're talking not just about women's rights, we're talking about pharmaceutical rights.
Absolutely.
This is a huge business. So maybe they're going to step back?
Yes, because I've done some interviews on this, and I said it's like the court, it must be so torn because on the one hand it loves business and on the other hand it hates abortion. What is it going to do?
So just two other points. Isn't this judges practicing medicine without a license?
It's certainly judges claim to have greater medical expertise than the agency with the medical expertise. And it's not just that this is, again, I have to emphasize, this is not a drug that's just been approved recently. This approval was over 20 years ago. So it's not like it's challenging a new drug. It's challenging a well-tested drug. And it's not just been tested by the actual women who've used it. It's been tested by hundreds of studies, many of which meet the gold standard. I mean, this is every medical professional group is just like, this is an absurd claim. And this is as safe as aspirin. This is safer than Viagra. I mean, no medicine is 100% never going to cause any problems. But this is really at that end of the spectrum. It's a very safe drug.
And my other point would be, and I mean, has been made by many people, that in the Dobbs decision, Alito took the stance that, this isn't for us to decide. This is to throw it back to the courts where we have seen the chaos this has created, women's right to abortion. But if the court was to uphold this ban, then it would be contradicting itself because it would be making a national decision on abortion, right?
So yeah, I take your point is that, right, one of the covers for their eliminating the right to abortion is that this is really a decision that should be left to the states. And if a state doesn't want to have abortion, it should be able to ban it. And if a state does want to have abortion, it should be able to allow it. And a ruling that mifepristone was too dangerous to be made available could really make abortion difficult, even in the states that do allow it. Now, the only thing I'm going to say, because I am a con law professor and I can't help myself, is that the FDA is, there is supposed to be a national agency to decide on the safety of drugs, and that role is appropriate. But clearly they are using a tactic to try and make abortion unavailable, even in the states that would like to have it available. So yes, they don't actually believe in federalism, right? This idea that states should have authority over these kinds of decisions. Clearly this attack is really not supported and is made not because they're worried about the safety of this particular drug, but because they're trying to use any possible means to make it unavailable for everybody.
Did you have another legal question, or?
Oh, no, go ahead. Finish your point, Professor Corbin.
I just want to have one small thing. As I said, the normal regime is a 2-drug regime. It is also possible to use only the second drug. Perhaps they don't realize this yet because they have not yet begun to attack it. If you use both of them together, it's over 99% effective. If you use just the second one, it's not as effective. I think the effectiveness drops to about 88%, but it's still available. So this is not at all to take away from the point that this is clearly part of the assault on allowing women to control their bodies and destinies. But medication abortion is not going to vanish, even despite all their shenanigans and despite any ruling of the Fifth Circuit.
So, Barbara, did you want to chime in on this before you give us the, I'm sure, grim update on legislation? Did you talk a little bit about this?
Sure. Well, I think it's also really interesting that we see states like Vermont who've recently passed legislation protecting medication abortion in the event that mifepristone is is further attacked by the Supreme Court. And I was just wondering if Professor Corbin had any comments on that.
That other states are making a concerted effort to try and protect it as much as possible. Yes, I think it's great. I think we're part of the problem is that there are large swaths of the country where that's not true. So it's not like these states are right next to each other. It's that there are, like, the whole South. It's just very hard to get an abortion now. So it's great that some states are making efforts to add another layer of protection, but it means, depending on where you live, is whether or not you can even easily get to another state and make use of that additional protection.
So, Professor Corbin, I have a question, and I don't want to get too in the weeds, but I'm really curious about this. So we know this whole thing, it's so transparently a really extreme, like a radical anti-abortion move to just make abortion unavailable and, just do away with abortion in this country and it's made all the more transparent by how safe this medication actually is. There just really is no reasoned argument. But I'm curious about the argument, I guess, from like the legal standpoint, the Comstock law arguments. Like, what is the strength, or have you been in the weeds enough of this case? And I know it's really bad. It's bad law, it's bad argument, and all of that. But nevertheless, it's being taken seriously by the courts. And I don't know, what is the strength of this Comstock Act argument?
Okay, I'm not. So I'll tell you what I know, which may not be much more than you already know. So again, I want to emphasize that this law was passed in 1873, right? This is a very, very old vice law. And it banned the sending through the U.S. mails anything considered, I think, obscene, lewd, lascivious, indecent, filthy, or vile. So that gives you a sense of what they were looking at. And they specifically said that includes contraception, things used for contraception or abortion. Now, Congress removed the references to contraception in the 1970s, but the language about abortion is still in the Act. Now, of course, there was a whole series of decisions that sort of undermine the vitality of the Comstock Act. So most courts today, I think, would not feel that it really could play a role. But the language is there. And so courts can construct the argument that on its face, it doesn't allow you to send medicine that is going to be used for abortion. And, and Roe v. Wade is no longer good law because that essentially nullified it.
Right.
But that law itself has been overruled. Now, again, the Justice Department said, listen, the Comstock Act does not apply if you're mailing abortion pills that are going to be used legally, right? I mean, so that's right. That's the general understanding of it. But
so
these courts are motivated.
I know.
The courts that are looking at the language of this act are motivated and will reach that conclusion.
So I'm hearing you say the constitutionality of the Comstock Act has not directly been attacked from 1873 to now.
I do not. I have not actually looked up all the various constitutional challenges to the Comstock Act because basically Roe v. Wade initiated its force, and so I don't really know what has. I am re-meeting the Comstock Act.
Right. It's like, do we now need to?
I have not actually looked into the sort of what cases have been made about its constitutionality other than the substantive due process.
It's unbelievable. But if the Supreme Court would cite Matthew Hale is he 16th or 17th century, who sentenced women to death for witches as a precedent. Why not the Comstock Act?
Right.
But Barbara's been waiting very patiently, and I'm wondering if we can now get to a summary of recent developments at the state legislative level, Barbara.
Absolutely. So there's been a couple good bills, but a lot of bad ones. And so I'll start off with the bad. Let's see. In North Carolina, they have passed a 12-week abortion ban. The governor is slated to veto it, but it appears that the legislators do have enough votes where they could potentially override that veto. So that's very concerning in North Carolina. In Idaho, what they deem the abortion trafficking bill has gone into effect. And basically what this means is it would be a felony to take minors out of state for an abortion without parental consent. People could face jail time and a bunch of legal fees and fines. And that's really concerning because minors already face so many barriers to abortion access. And this is also going to impact how people talk about abortion. It's going to further stigmatize abortion because people are going to be afraid about being put in jail or getting a loved one in trouble for helping them get an abortion. So that's very troubling. In Tennessee, Governor Bill Lee has set aside $20 million for anti-abortion centers. As I mentioned earlier, anti-abortion centers, also known as crisis pregnancy centers, they spread misinformation and they push scare tactics. They do not provide medical services, and their sole purpose is to dissuade people from having an abortion. And yet there is this increase in funding. Tennessee is just one example of that, $20 million.
Now, in Tennessee, abortion is illegal, and yet they're going to put money aside for these so-called crisis pregnancy centers. It doesn't even make any sense.
That's exactly it. And that kind of goes along with my piece earlier about how this is not just about public health. This is not just about health access, but it's also an information access concern. If we have this duality of restrictions on healthcare and then also funding of blatant disinformation, that's creating this ecosystem where not only people don't have access to healthcare, but they also are facing barriers to learn where they can get abortion care. So that's really troubling. In North Dakota, their governor recently signed into law a 6-week abortion ban. And then in Florida, Governor Ron DeSantis has also signed a 6-week abortion ban. The Florida Supreme Court has been reviewing the legitimacy of a 15-week abortion ban. And so depending on that decision, the 6-week abortion ban may be allowed to take effect. Let's see in Utah, they have a new law that's set to go in effect that would essentially drive abortion clinics out of state because the law would only allow hospitals to perform abortions. However, in Utah, hospitals only provide abortions in medical emergencies. So that essentially is going to make abortion care inaccessible in Utah. And Planned Parenthood Association of Utah is asking the 3rd U.S. District Court of Appeals to put a hold on the law. No decision has been made just yet. But I also want to say, aside from state legislation, there are also, this is really important for us to be involved on all levels, not just be aware of what's going on national levels and state levels, but also within our own communities. We're seeing this right now in New Mexico, where abortion is legal, but the town commission of Edgewood has approved an ordinance that would prohibit abortion medication via mail and would also allow citizens to sue anyone for violating that. So that's really troublesome, and that's happening on a local level in a state where abortion is legal, essentially saying that people can take abortion restrictions into their own hands. So we need to be vigilant on all levels of government.
What about South Carolina?
I do want to say a couple of, I'm hesitant to say good news, but positive, I suppose. In South Carolina, they narrowly defeated an anti-abortion bill by 1 vote. Now, that's the 3rd time that they've had an anti-abortion bill go through or attempt to become a law this year. And while it's wonderful that it was defeated by 1 vote, I think it's pretty clear that they are going to try again for another anti-abortion bill this year. And so we're not in the clear yet. Nebraska also defeated an anti-abortion bill just by one vote. So, these are really, really close calls. In Washington, the governor, Jay Inslee, signed a really important piece of abortion protections. It's the first ever protection that would protect consumer health data. So this means information on period tracking apps and location records that might show if somebody visited an abortion clinic. That is going to be protected, and that's a really important law. I mentioned earlier about Vermont passing a bill to protect the abortion pill, and Massachusetts Governor Maura Healey has also taken steps to protect abortion medication. And as we've talked about, those are important steps to take right now, but it certainly is not a panacea. It just creates a patchwork of abortion access in this country. It will still be largely inaccessible for so many people. And this is all very unfortunate, not only because abortion is health care, and that's backed up by evidence-based studies and science, but beyond all of that, the majority of Americans support abortion. And we saw that in a new Pew Research study that found that 43% of Americans say that abortion should be easier to obtain. This is a 12% jump from 2019, where just 31% of Americans said that. And overall, 62% of Americans believe that abortion should be legal in all or most cases. So that's what's going on across the country.
Wow, thank you for that survey. It is very grim, and especially to see what's happening in the South, where there's basically going to be no place anyone can go if Florida does fall, if the courts rule that 15-week and 6-week constitutional. And it's amazing to me that South Carolina would be our stronghold right now. I would not have expected that.
I actually live in Florida, and Florida definitely has been the place that many women come to. And what's interesting about Florida is, unlike the federal constitution, the state constitution has an explicit right to privacy in it. And the Florida Supreme Court has repeatedly held that Florida's right to privacy protects the right to abortion. And previously, the courts have actually provided more protection for abortion than the federal constitution ever did. So, as a matter of basic law, these attempts to outlaw abortion are clearly unconstitutional under Florida's state constitution. The only problem is, like the federal Supreme Court, the Florida Supreme Court has gotten super conservative. And so once again, they may manipulate the law to reach the conclusion they want, ignoring precedent and sort of the obvious meaning of the language of the Florida Constitution. That could be a real problem, because Florida was the place that people came.
Is there any sense of when they'll reach the question on the 15-week abortion ban? Because that's been brought under the state constitution, right?
Yes. So yeah, the 6-week ban says if the 15-week ban is upheld, we're going to immediately move to a 6-week ban.
Wow.
And I do not know the timing of their decision.
Well, thank you both for your wonderful information. And do we have any questions?
Oh, yes. Let's see.
Let's see while
Anybody
we wait.
asking questions on Facebook here?
Or making comments. Everything's moving so fast, as you both show, and especially at the legislative level. And I'll be looking forward to summer breaks there, and hopefully a little cessation of some of these bans. Do we have any questions, or we're looking?
Sorry, just a technical.
I can't imagine we don't. Anything else you wanted to add, Barbara, while we wait for this?
No, I really appreciated learning a lot about what's going on from a legal standpoint this afternoon. Really important.
I know, Barbara, you and I subscribe to Jessica Valenti what's it called? Abortion a Day?
Abortion Every Day.
Every Day, where she, because it's so hard to follow. And Katha Pollitt recommended it to me, who writes for The Nation. Mm-hmm. And so that's a really good way for anyone interested to stay informed on everything.
So I guess I also want to just do a shout out while we're doing the technical troubleshooting. If people are looking for a way to get involved, it can be really disheartening to see all of this news. Subscribe to FFRF's action alerts and also consider contributing to an abortion fund that help people travel for abortion care. So those are two ways that people can get directly involved. And as I mentioned, make sure that you are involved in all areas of government, including on a local level too.
Yeah, I think that URL is out of date. You can go to FFRF Action Fund now. We have a C4 arm that does the action alerts. Just go to FFRF Action Fund, and you can sign up under the action section.
So that kind of speaks to one of the first questions that we're getting from Facebook, Barbara, which is, what are some ways I would be able to fight for abortion rights and help educate others on reproductive justice if I live in a state where it's heavily restricted? And that speaks to, I think what you're communicating today, Barbara, is that this is as much of a issue of information access as it is care access in some of these places where abortion, the procedures are so heavily restricted that a lot of activism needs to revolve around information. So any other thoughts for someone who is in a place where access is really restricted in terms of activism and things that they can do?
Well, I read a quote last year after the Dobbs decision that basically said, if you want your money to go towards somebody receiving an abortion, your best bet is to donate to a local abortion fund. And there is currently a fund-a-thon going on across the country. Abortion funds throughout the country are uniting to raise money that will go towards people seeking abortion care. In Wisconsin, the Women's Medical Fund, otherwise known as WMF Wisconsin, which was founded by FFRF co-founding principal and Nicole Gaylor, is currently raising money for abortion funds. And so donating is a form of mutual aid, and that's a way that you can make sure that your dollars go towards somebody receiving an abortion. In Wisconsin, people have not been able to have an in-clinic abortion since last June because of an 1849 anti-abortion law. The oral arguments have commenced for that, but the future is still very unclear. And so that means thousands of people in Wisconsin are without abortion care. And so consider donating to an abortion fund and educating yourself about what's going on. You can subscribe to the Free Thoughts Now, where we have at least weekly posts about what's going on in abortion. And those are two, yes, that I write. And I love writing them. And I usually include some action steps in them. And you can go into the archives and also see what I've written, because I've been writing for FFRF for 3 years now. And you can see posts about how you can communicate abortion as a secular issue, abortion as a healthcare issue. I know FFRF has a really great non-tract about how abortion isn't even mentioned in the Bible, and yet it's being used by Christian extremism. So there's a lot of education available, and communicating that to people is really important.
So there's another question here that is a little going back to the mifepristone lawsuit. Why do judges get to pick and choose what they believe from government agencies such as the FDA? Doesn't this defeat the purpose of these agencies being established, which, of course, federal agencies are sort of delegated power from the executive branch, and they are tasked with doing these big jobs like evaluating safety, food and drug safety, among millions of other things. But what is the basis by which judges are claiming the power to pick and choose, what's appropriate for the FDA to do when they're conducting safety trials?
Yeah, so they don't, right? And that's why this decision is a first. Judges don't usually second guess the FDA's scientific findings because they lack the competence to do so. And I think this becomes particularly clear when you contrast this lawsuit with another lawsuit involving mifepristone, which was going on at the same time, where you had 17 attorney generals from the states challenging the fact that the FDA had additional restrictions on the drug that were very rare, right? So they have approved like 20,000 different drugs, and there are only 60 that had these additional restrictions. And they're usually things like fentanyl, not things like mifepristone. And so you had a challenge from the left saying, you know, the FDA's additional requirements that made this harder to access was really politically motivated and shouldn't stand. And it went before a judge, and a judge did what judges normally do and was more deferential to the FDA's finding of fact and said, listen, it's really not appropriate for me to second guess their determinations like this particular one. And so the judge didn't. And I think that's more typically what you see, not that the FDA is, you know, without flaw, but it does highlight how unusual the decision out of Texas was.
So this is a question we get fairly often that we can take up, Annie Laurie. What is the state church issue with abortion?
Oh. Well, maybe some of our guests would like to respond. I heard a gasp there.
It's kind of a how much time do you have situation.
I'm actually writing something about this, which is, you know, clearly these should violate the Establishment Clause, right? I think most of our viewers would understand that opposition to abortion is based on the religious idea that life begins at conception. This is a religious idea, right? The people who hold this hold it because of their religion. And in our country, laws are not supposed to be codifying one religious perspective and imposing it on everybody else. And so one would think that, well, isn't this kind of like a little theocratic, and shouldn't it be a problem that states should be passed for secular justifications, not just religious ones? And I think you would be right. Like, I think this should be considered an Establishment Clause violation. But when the Supreme Court considered an Establishment Clause challenge to abortion, their argument was, well, you know, opposition coincides with some people's religious beliefs, but that doesn't make it unconstitutional. And they're like, you know, laws against stealing coincide with some religious beliefs, but that doesn't mean that laws against stealing are unconstitutional. They just happen to coincide with the religious belief. And of course, the answer is like, yeah, but there are a lot of reasons other than religion to ban stealing, and there are really no reasons other than religious ones to ban abortion. But the court didn't really acknowledge that. They just like, people oppose it for traditional reasons without actually articulating what those traditional reasons are. So the long and short of it is the courts, and that was when the Establishment Clause actually existed, unlike now, where it's been pretty much eviscerated. So the court is not going to entertain a separation of church and state challenge, even though this is so clearly an example of a union of church and state, namely the state passing a law that the church and only the church wants.
And based on religious ideology, that what some denominations teach about ensoulment, when life begins, that this is God's will, et cetera, et cetera.
It all comes down to this idea that life begins the moment of conception, that it's ensouled, that it has the moral value of a born person. I mean, these are deeply held beliefs, but these are deeply held beliefs held by some people, not all of us.
And they shouldn't have abortions, right?
Well, that's, I think, so important to understand, is that the prior regime really allowed everybody to live out their faith, right? As you said, if people are opposed to abortion, they didn't have to have an abortion. But if people had very different religious beliefs, like Jews who think that life, right, that the pregnancy is just part of the woman's body, then they too can live according to their faith, which is not opposed to abortion, and in some instances requires it.
And those of us who are not religious, who shouldn't be dictated to by other people's religions. And
again, yes, sorry, I agree.
I think public opinion really shows that most American people really understand this as a concept, even if they're not, understanding it in this way that we're articulating it, that this is just such a personal, conscience-based choice that involves so much personal decision-making about how we value all of these different, sides of this question. I think that is why there's so much support for this being a personal, not a state decision, and for abortion being available as a choice in most or all circumstances. So.
Yeah, I think we have to wrap this up, but I do want to quote a Representative Laurie book. You may have caught that, Professor Corbin, where she testified against this. She was arrested for peaceably assembling against the 6-week ban in Florida. But what she said on the floor really struck home with me. She said, nobody is going to save us but ourselves. We just have to make this a priority to save reproductive rights in this country. And we really appreciate both of you for the work you're doing and for joining us today.
Amen.
Thank you.
Well, that concludes Ask an Atheist for this week. And thank you both so much again for joining us. And thank you for watching. Before we promote our other programming, I would like to mention that next week on Ask an Atheist, we will be having a very special guest on the show, God.
Hi, everybody.
It's going to be an interesting discussion, to be sure, so don't miss it. And be sure to tune in to FFRF's broadcast TV show, Free Thought Matters. This week, Laurie and Dan Barker will speak with Michelle Dowd about her new memoir, Forager: Surviving a Family Cult. This is a preview. She's describing what it was like to be female in a dominated cult culture.
We had more men than women, and that is not true, certainly in all churches. We had far more men than women because it was designed as a male organization. And we were not just second-class citizens. I think we weren't really citizens in the community. We were vehicles for children. We were being raised to have the next generation. And I did not see my body as a temple of God the way that I think some people interpret the Bible as saying that God gave us this body and we should, purify it. What I felt is that it was a burden to be born female, and that it was a punishment because Eve ate of the apple and wanted knowledge, and that the worst thing a woman could want was knowledge. And even though I continually wanted knowledge, I felt bad about wanting that knowledge, and that was definitely something that I was punished for.
You can see Free Thought Matters Sunday mornings on TV stations all across the U.S., also on FFRF's Facebook and YouTube channels.
And don't miss Free Thought Radio. This week, I'm not sure we have a guest set up, but you can tune in on Thursdays, and it's a podcast you can get everywhere. FFRF.org/radio.
And be sure to catch the latest episode of the We Dissent podcast, where Allison Gill, Rebecca Markert, and I talk about court reform with Katie O'Connor of Demand Justice. Listen, subscribe to We Dissent anywhere you get podcasts, or check us out online at we-dissent.org. We will see you next week.